Yay. The Supreme Court of the United States is now in session. The Honorable Chief Justice Joan Biskupic presiding. All those having cause to be before this honorable court, draw nigh and pay heed. God save the United States in this honorable court. Please be seated.
All right, we made it. We did it.
We will now hear arguments in the combined cases of Bostock versus Clayton County and Altitude Express versus Zarda. Mr. Unikowsky, I understand you want to reserve 3 minutes of time for rebuttal? Okay.
Madam Chief Justice, and may it please the court. The employees in this case were fired because they're men who are attracted to men. If they were women who are attracted to men, they wouldn't have been fired. As such, this is a straightforward case of discrimination because of their sex in violation of Title VII. I think a straightforward hypothetical will explain why we really think this is a case of sex discrimination. Suppose you had an employee who worked in a different office from the employee's boss, but regularly emailed the boss and referred to the employee's husband. And say the employee's name was Chris, so you couldn't tell whether it was a man or woman. So one day the employee shows up at the main office and meets the boss. And the boss is shocked to learn that the employee's a man. And the boss says, look, if you were a woman as I had thought, you wouldn't be fired. But because I now see in front of me that you're a man, you're fired. So it's hard to see how that's anything other than discrimination because of sex when the person's literally being told that they're fired because they're a man as opposed to being a woman.
Counsel, can I ask you, though, you rely a lot on the text of the statute, but the text actually says because of the individual sex, doesn't it? And they're talking about the individual, the employee's sex. And doesn't that suggest that it should be a test that can be discerned by looking at the individual alone without this kind of associational aspect? That seems to go beyond the text of the statute.
I don't think it does, Your Honor. I think that what the text of the statute says is you have to determine whether or not, if you hold the facts the same but change it from a man to a woman or from a woman to a man, the employment decision would have been the same. And the hypothetical I just gave, it's clear that the person's discriminated because in that particular scenario, it's a man versus a woman. Now, it's true that only a subclass of employees are discriminated in the sense, not all employees, but only men with husbands. But still, in the Phillips case, this court held that that form of sex plus discrimination was recognized under Title VII. So in that case, women with children were discriminated against. And that was held to be discrimination because of sex, even though only a subclass of people with children, encounter discrimination.
Can I ask you how that applies in the context of grooming standards? So what if I keep your hypothetical exactly the same and say, if you were a woman with long hair, you wouldn't be fired, but because you are a man with long hair, I'm firing you. I mean, under your sort of straightforward textual, that's also sex discrimination, right?
So I think that is sex discrimination, but it might not violate Title VII for a couple of reasons. First of all, I don't think that's really necessarily an adverse employment action. Maybe not be discrimination in the terms and conditions of employment.
Well, if I fire you for having long hair, that's certainly discrimination in the terms of conditions of employment.
Well, in that case, you'd be fired for violating the rule, and if the rule itself is not discriminatory, then I think that there's a neutral reason for firing the person that you violated the rule. But I think the more pertinent point is that it's not as though our position inexorably leads to the consequence that you can't have sex-specific grooming standards in a way different than other decisions of this court have already done so. So take, for instance, the Dothard case, right? So in that case, the court held that there's a rule that said that men who guard men in prisons and women who guard women in prisons, that rule discriminated on the basis of sex. And that argument would just as inexorably lead to the consequence that you say is an absurd consequence as the argument we're making in this case. Because in that case, too, there was one set of standards for men and there was one set of standards for women. There wasn't discrimination in the aggregate because men could guard men and women can guard women, and yet the court held that that was discrimination. And so,
counsel, you'd have no problem with transgender discrimination if it were, right? If it was a transgender employee who might be biologically male, grooming herself as a woman, that would be okay to discipline or dismiss that employee.
We don't think so. We agree with the position that's being advanced by the transgender employee in the companion case here. I think it would just depend on the specific standard. Look, I think that as was bandied in the briefs, it seems to me that a rule that said that men could wear suits and ties, but women had to wear sort of revealing clothing, that would violate Title VII without question. I also think that, a rule, for instance, that said women can't wear pants in the workplace, but men can, that might also violate Title VII. I think you have to look at the specific rule. I don't think.
But counsel, all of those would be addressed by stereotyping, I think. And what I'm really interested in to know is, what does your claim here add beyond the jurisprudence of sex stereotyping? Why doesn't sex stereotyping already cover this?
I think that actually, in many ways, the Price-Waterhouse case resolves this case. It's almost a special case of the Price-Waterhouse case. So the Price-Waterhouse case holds that a woman who was fired because she failed to adhere to gender stereotypes stated a claim under Title VII for discrimination on the basis of her sex. And I think when you read the reasoning in that case, it's pretty clear that a similarly situated man could also have stated such a claim. In other words, it wouldn't have been a defense to liability in that case if the employer had said, well, we fire all women who don't adhere to.
Okay, but here's my question then. If you rely on sex stereotyping, does an employer have a religious defense if it's not a stereotyping basis for firing somebody who's gay or lesbian, but it's based on a religious viewpoint? It has nothing to do with stereotyping behavior. I think it's just a religious view. Is there a religious defense then against stereotyping?
Well, there is the ministerial I don't think there's a general religious exemption for all employers under Title VII, in the same way that even if employers have a strongly held view that women with small children should stay at home, you can't fire women with small children.
But this would be a constitutional defense.
Yeah,
What's your position on that?
Yeah, so we agree the ministerial exception will apply.
No, that's a ministerial. That's a text-based statutory argument. I mean a constitutional argument for any employer.
Yeah, I think so too. So this court has also grounded the ministerial exception in the Establishment Clause. If Congress failed, there's a debate over whether the statute itself has a ministerial exception. If there wasn't, I think the Establishment Clause would require one. If it's a religious institution.
No, it's not a religious institution. It's just a regular, everyday employer.
Then no, I don't think that the Free Exercise Clause would prohibit, saying that.
You don't think under Hobby Lobby there's some defense based on religion, an employer who doesn't want to hire someone based on their own religious views?
Well, two things about that. First of all, Hobby Lobby applied the RFRA rule, and it's not clear that there's a free exercise clause defense. It might be under Employment Diversion versus Smith. That rule arguably would be a generally applicable rule. And second of all, Hobby Lobby was a closely held company. There's some debate in Hobby Lobby whether it's different from all employers. I do think, though, look, there may be some scenarios in which maybe some small, closely held employers might have a religious objection to employing a gay or lesbian person, and those cases can be litigated. But I think that's not true in the mind run of cases. Look, there's a lot of employers with very sincere beliefs against same-sex marriage who don't think that all gay employees and lesbian employees should be fired.
So in your view, why wasn't Obergefell a sex discrimination case? Why did the court make Obergefell so much harder than it needed to? Because under your logic, Obergefell was a straightforward example of sex discrimination. We should have applied intermediate scrutiny. Done.
Well, first of all, I think that it was just, there's an alternate basis for making the decision.
But that's not the basis the court gave. Why not?
Well, because the Constitution does not explicitly prohibit discrimination on the basis of sex in the way Title VII does. The court grounded the decision in equal protection and due process principles, as in several other gay rights cases before that. It seems to me if the Constitution had just decided you can't discriminate because of sex, that probably would have been the textual basis for reaching that ruling.
Counsel, isn't it, am I correct that every year members of Congress who would be sympathetic to your clients try to change this law to include sexual orientation, and every year they fail? Is that a pretty good indication of what Congress thinks that this law says?
I don't think so, Your Honor. I don't think so. You're right that there have been several failed attempts to add sexual orientation. Pretty much every year. That's correct, Your Honor. But first of all, I don't think that post-legislation activity really sheds that much light on what the text of a statute enacted in 1964 means. It's axiomatic.
Are you saying then that the Congress in 1964 believed that it covered sexual orientation?
I'm saying the text of the statute covers it, which I think is ultimately the deciding factor. This court said in the Onkale case, and we certainly reiterate, that the laws are what govern us, not the intentions of the legislators who voted for them.
And so what if the plaintiff was bisexual? And what if the plaintiff was a woman, she was bisexual, but she happened to be with a man at that time? What would Title VII have to say about that? Because if you swap it out, and well, what would Title VII?
I think a woman who is fired for being bisexual, that would violate Title VII.
Okay, articulate your reasoning. And would it be different from being fired because you were homosexual?
No, I think both of those people would have a claim under Title VII.
But if you're doing it tagged to the comparator between the male and the female. It just seems like your argument is very binary.
Well, okay, so I first of all, the answer is yes. I think that a woman who is bisexual would have a claim under Title VII because it's still because of her gender. And so, I think maybe the better argument in that case would be both sex stereotyping and the associational claim. So the sex stereotyping claim would be that a woman who is interested in having relationships with women, even if she's also interested in relationships with men, isn't adhering to traditional gender stereotypes, that a woman should only be in relationships with men. There's also an associational discrimination argument in that scenario, in which you'd say that because a woman wants to associate with women, that's sex discrimination because you're considering her desired association in that decision. So I do think that the arguments we make would also apply to a hypothetical bisexual. If I could just respond to the question a little bit more about what Congress was thinking in 1964. So, of course, it's axiomatic that we're governed by the laws that exist rather than the intentions of the legislators. I think there's actually two reasons in this specific case why that's a particularly salient point. First of all, there's a lot of evidence that actually in 1964, the ban on sex discrimination was a kind of poison pill meant for the whole bill not to pass. That's what the court said in Price Waterhouse. So if we were serious about implementing the intent of the legislators, we'd never apply the statute, which clearly is not correct. And so what the employers are imagining is this like hypothetical composite legislator that supported the passage of the sex discrimination bill because of a certain set of views about women and men in the workplace, but also harbored the kind of private biases against gay and lesbian people that hypothesized to have existed in 1964.
The difficulty, though, is that it's not just 64. It's not just that they've tried year after year after year to impose this new classification on the statute. It's not just that they have imposed this classification in other statutes. It's that all those things rolled together just make the argument feel perhaps more clever than right.
Well, I mean, I'm mindful of those points, but I'm happy to go through them one by one. I don't think any of them shed light on what a statute enacted in 1964 means, which turns on the words in that statute itself. So on one of the points you raised that Congress regularly added sexual orientation to statutes, a few things about that. First of all, the reason it did it is because of the argument we're having this afternoon. I think Congress recognized that there was at least that the word sex would not be construed the way we're supporting, and they decided to make it explicit. But I don't think that means that kind of retroactively the statute was, from years earlier, was amended to exclude the protection from gay and lesbian people. Also, many of these statutes recite both race and color, for instance. And the fact that you did that doesn't mean that if you took out color, then someone who was discriminated on the basis of color couldn't assert a race discrimination claim. I don't think that the existence of the two words implies that if you take one out, the second one suddenly becomes narrower.
Counselor, should it give us some pause if we're talking about the original meaning of the statute in 1964, that for decades every court that considered the matter said the opposite of what you're saying, and they were closer in time to the enactment than we are. And the EEOC, which was not famous for timid interpretations of the statute in the early years, I'm thinking of Griggs and disparate impact, they didn't take the view you're taking either until very recently.
So I actually think the history is a little bit more complicated than that. There's an interesting amicus brief by the historians that make it seem a little bit less one-sided. It seems that in the history is a little bit spotty, but in the early years after the statute, the EEOC kind of reached both conclusions. It's not as though no one thought of this argument. Claims were asserted by gay and lesbian employees. Eventually, the EEOC did issue a ruling about a decade after the statute was enacted, which is consistent with the employer's position. But there's just a couple of Court of Appeals decisions that are barely even reasoned, right? Like there's one of the Ninth Circuit case is just all about the legislative history and presumed objectives, arguments that you wouldn't get in an opinion today. And then I think there's the Fifth Circuit case, which has like one conclusory line. And I simply don't think that those cases create a kind of adverse possession on the statute, that what their construction of it is.
But wouldn't Congress have been aware that in many states at the 1964, homosexual conduct was actually a crime? So how could they have thought of protecting one's employment status when they were taking no action to address the fact that there were criminal sanctions in many states?
I mean, it's not obvious Congress even had the constitutional authority to preempt state statutes criminalizing homosexuality. Congress was solving a different problem, which was employment in interstate commerce, and it solved that problem in a particular way. And I think that there's certainly an intuition that in 1964, private biases held by a hypothetical legislator at the time would have created a desire to put in a hypothetical exception into the statute. But I think today, there's not a lot of policy defense on the employer side of the practice of firing gay and lesbian people. And it seems to me that we should follow the text of this statute rather than sort of inserting an atextual exception based on hypothesized biases that don't even really exist anymore.
Well, talking about relying on the text, though, I mean, that's, I guess, where I keep coming back to the stereotyping and why why anything beyond that is needed. And perhaps if it's per se because someone's gay or lesbian, maybe that's not covered, but any kind of actual stereotyping is. And then I realize you have this associational argument. What is your best case for that associational argument? Really, that's certainly not in the text of Title VII. Where does that come from? I realize they're lower courts, but what's your best anchor for that in Title VII?
Well, I think there actually is a textual anchor, because if it's based on the sex of the other spouse, it's still on the because of sex in some sense. It may not be because of your sex,
But it's because of the individual sex. That's what Title VII says.
right. Well, but it does say that. But it's not just the sex of the individual. It's the fact that it's the interaction between the sex of the individual and the sex of the spouse. So it's a similar kind of argument, right? Like, because you're a man in a relationship with a woman, or with a man versus a woman in a relationship with a man, the analysis focuses both on the sex of the employee and also on the sex of
But have we held that, or is that really just lower court precedent?
Well, it's mostly lower court precedent, but look, all parties agree in this case that firing someone because they're in an interracial marriage would violate Title VII. That's not disputed. The only question is,
race is always the easiest place. What about age? Say you're dating somebody or you're married to somebody who would be protected within the age, but you're not, the age bracket. On the other hand, you think, well, that person's going to want to retire early because their partner is going to retire early. You really think that's covered by the Age Discrimination Act?
well, I think the Age Discrimination Act itself says that if you're under 40, you can't assert a claim, as I understand it, as an element of the statute.
But what I'm saying, under your associational theory, if that's text-based, you could, based on your spouse being within the protected age
So
limit.
I don't think the associational claim is solely based on just look at the sex of the person you're married to. I think it's based on the association between you of being one sex and the spouse of being a different sex. I don't think it's just looking at the spouse of the other, at the sex of the spouse. So I think there's an analogy to the racial discrimination claim where, the fact that so everyone agrees that firing someone for being in an interracial marriage violates Title VII because you have a right to associate with people of the opposite race.
Have we ever held that? I mean, I know you say everyone agrees, but have we held that? It might violate a lot of things. I'm just asking whether it violates
This
Title
court,
VII.
when I say everyone,
Title VII.
no, this court has never held that. But I think all the employers in this case agree with that. And the argument that's made is not that that would be legal, but that racial discrimination is just different. It's more malign than discrimination on the basis of sexual orientation. I'm willing to concede that. I'm willing to concede that you're a bad person if you fire people in interracial marriages in a way that you're not necessarily a bad person if you oppose same-sex relationships. But I don't see how you can get out of the statute at all. There's plenty of cases that said that even legitimate motives for discriminating violate the statute. The classic example is the Manhart case, where there's discrimination based on the actuarial reality that women live more than men, and pensions were tailed to that. That wasn't malign, it wasn't evil, it was based on mathematics saying that women live longer than men, but it was still sex discrimination.
But we did have Gilbert, right? I mean, the statute had to be amended to cover pregnancy. So, if you look at that rationale, I don't know if your argument holds up.
Well, I mean, I'm not certain that Gilbert would have come out the same way today. I mean, Congress...
It hasn't been overruled, right, except by the statute.
Well, I mean, the question became moot once Congress overruled.
Well, that's not true, because we said the same thing under the Constitution. We said pregnancy discrimination was not sex discrimination under the Constitution, and that's never been overruled.
Well, but the Constitution does not explicitly prohibit discrimination on the basis of sex in the way Title VII does. I mean,
that doesn't work.
It's been
though, because
construed on the equal...
The Constitution doesn't expressly prohibit race in the way that Title VII expressly prohibits race either, so I'm not sure that works.
No, look, I think that Title VII specifically talks about sex, and so I think that you have to follow the text. There's a lot more flexibility. I mean, intermediate scrutiny is a judge-created standard, right, that applies to gender classifications under the Constitution. I don't think you can just insert intermediate scrutiny into Title VII, which just explicitly says because of sex. I think that you just have to interpret those words literally when those are the words that were provided by Congress. But I would like to just say one other thing, by the way, about this notion of in 1964 Congress wouldn't have intended this, because I actually don't think this is a debate between what Congress would have intended versus what the statute says, because we haven't talked much today about how it's difficult to disentangle sex discrimination from sexual orientation discrimination. I actually think they're very difficult to disentangle because for a lot of people, acting effeminate is equivalent to being perceived as gay. But the argument by the employers would require juries to distinguish between those two things, right? Is it really because they were effeminate or really because they were gay? And that line being drawn by juries is not a line that Congress would have anticipated in 1964 either. So I don't think this is a debate between the text text and contra the intentions versus the intentions and contra the text, I mean, both sides imagine a statutory scheme where juries are doing things that could never have been imagined in 1964. And when we're in that world, it seems to me you should go with the text rather than the implied exception to the text that the employees are advocating in this case.
Counsel, can you address some of the limiting principle issues that have been raised in many of the briefs in terms of if this is something that an employee can claim is due to their sex, what about someone with a disability or someone some inappropriate, say, behavior by a male employee, and it's really the behavior that is disturbing the workplace, but that employee, under your thesis, could perhaps just say, oh, you're discriminating based on my sex, or you're discriminating based on my disability, not the behavior that I'm exhibiting that is disturbing the workplace.
No, I don't think that's the case. I mean, it's hard to see how that would work in the world of sex discrimination. I mean, disability discrimination, it's hard to imagine a specific hypothetical. If someone has a disability that causes them to be incapable of working, there's exceptions in the ADA that would allow the employer to fire the person. There is some flexibility for people who are incapable of doing the job. I'm not sure of, in the sex discrimination context, what the reductio is exactly. And now, maybe this is related to the question you asked. The government's brief talks about, sex-segregated bathrooms or sex-neutral bathrooms is the implication of our position. And I just don't think that's the case for a couple of reasons. First of all, again, I don't think that's an adverse action in the same way that we're saying. And second of all, that's the logical implication of plenty of other decisions of this court already. If you accept the premise that a rule that discriminates against men and that separately discriminates against women can violate the rights of both, like in the Dothard case where men had to guard men and women had to guard women, then you've already accepted a premise that a rule that sort of in the aggregate treats men and women alike but discriminates against individual men and individual women violates Title VII. And when you're in that world, it's not like our position leads to sex-neutral bathrooms in a way that prior cases didn't already lead to sex-neutral bathrooms. So it's sort of
following up on Justice Brinkmann's hypothetical before in the ADA context. What if you had a 62-year-old employee who married a 17-year-old spouse, and the company found that distasteful and dismissed the older employee? Would that be an age discrimination violation?
Yes, I think that absolutely would be age discrimination, yes, because pertinent to the decision was the fact that the person was 62 rather than younger. So I would have no difficulty with that. If it was the other way around, if the 17-year-old were fired, I don't think the statute would allow that claim because the statute requires the individual to be more than 40. But that's a classic
Have
example.
any courts adopted that associational view outside of the race context?
I don't think so. I mean, the sexual orientation litigation is pretty recent. There's only a few courts.
No, I mean even in the age discrimination or any other protected classification.
I'm not sure that's been litigated. I'm not sure one way or the other. But I think your example illustrates how the associational claim turns not just on the sex of the partner, but on both sexes, right? There, the issue is not the fact that the spouse is 17, it's the interaction between the two ages. And if the age of the employee had been younger, the employer wouldn't have fired them. So even though they're being fired because of the association with the 17-year-old, it's still because of the employee's age in the same logical sense that in the argument we're making today. I will reserve the rest of my time. Thank you.
Thank you, Mr. Unikowsky. Mr. Gornstein?
This way. Madam Chief Justice, and may it please the court. Title VII's prohibition against discrimination because of sex does not ban discrimination because of sexual orientation. They are two different forms of discrimination based on two different personal characteristics.
Can I ask you just a quick question? And forgive me if I'm oversimplifying this, but would it violate Title VII for an employer to refuse to hire women who, let's say, like to smoke or like to curse, but to hire men who like to engage in the same behaviors? Would that
No, that is exactly what the cases say an employer could not do. Okay. And so there you're saying,
this is different.
So there you're
who like to date women as opposed to men who like to date women.
All right, so the comparison, what the problem is the comparison between a gay male and a heterosexual female, that's the comparison, doesn't answer the Title VII because of sex question, because it doesn't answer the question whether the difference in treatment is because of sex or because of sexual orientation. And in order to rule sex
but I guess I worry that, is that just conclusory or is that just me? I mean, it sounds like Your opponent says, sure, it violates the prohibition on sex discrimination for the same reasons that Newsom's hypothetical violates the.
So, and I'm going to try to explain why I see the difference, why there's a difference, which is, in order to rule sex in, you have to rule sexual orientation out. And in order to do that, you have to compare males and females who are similarly situated in terms of their sexual orientation.
But counsel, how does that work with Justice Barrett's question about bisexuality? I mean, if the employee is bisexual.
If they're bisexual, then they would be, as long as they're treating all bisexuals the same, there wouldn't be discrimination because of sex. As long as they're treating males and females.
So under your theory, if there is a hostile work environment, blatant sexual harassment, so long as men are sexually harassed and women are sexually harassed, no one has a Title VII claim.
So I think that's right if it's the same supervisor who's doing the harassing. If it's
a hostile work environment, it's the environment.
If it's an equal opportunity harasser, that's not discrimination.
And you think that furthers the text and purpose of Title VII?
Absolutely, because this doesn't just prohibit harassing conduct.
But what about such individuals' sex? I mean, this goes back to...
Again, it's as long as you're talking about say a bisexual supervisor who is harassing both men and women.
No, I'm just saying a straight harasser. I mean, in Onkale, there was no suggestion that there was any, it was just sexually based harassment by, I think everybody there was heterosexual. It doesn't have to do with their sexual orientation at all. I'm just talking about no sexual orientation.
The question is it because of sex or is it not because of sex?
Right, so let's talk about Onkale, right? No sexual orientation, all heterosexual, all male. It's on the oil rig. There were no women on that oil rig, right?
Right, but the discrimination was in discriminating against him because of his sex. A woman in the same position would not have been treated the same way.
Oh, that was not the finding of the court, I don't believe. I think they found that the discrimination was of the sexual harassment, and it was sex-based. The discrimination was sex-based. I don't think it was a finding that they wouldn't have treated a woman that way.
So the court never reached a conclusion about whether there was discrimination because of sex, but it said in order for there to be discrimination because of sex, it would have to be a decision that was because of sex and not for some other reason. And in order to show that there's discrimination because of sex, you have to show that there's a difference between how someone would have been treated if they were a person of the opposite sex.
So if everybody's sexually harassed, your position is no Title VII?
So again, I say, if it's different supervisors doing it, then I think that each one is a different act of discrimination because of sex, and then it's exactly like the Price Waterhouse situation. Let me go back to the Justice Newsom's, sorry,
Judge Kev, that's what my kids call me.
Hypothetical, and explain why this is the way the comparison test always works. Take Phillips. What you're looking at is, are they similarly situated in terms of the alternative trait that's been identified? So in Phillips, the alternative trait is young children. So you compare males and females who are similarly situated in terms of having young children. You see males get a job, females don't get a job. Same thing with Manhart. The alternative posited explanatory trait there is life expectancy. So you compare males and females who are similarly situated in terms of life expectancy, and you find that females have to pay more. So here, the alternative explanatory trait is sexual orientation. So in order, you have to...
Alternative explanatory trait was simply the sex of the other individual. Men
but
the
policy that's being challenged, what the assertion is being made is that sexual orientation discrimination is discrimination because of sex. So the alternative posited explanatory trait is sexual orientation.
But that seems very strange to me. So so imagine a society, as I gather that some societies have no legal conception of sexual orientation. And your argument suggests that if our society had no legal conception of sexual orientation, then we'd be back in the Newsom hypothetical where, so liking to date women is just the equivalent of liking to smoke. And if our society didn't have that category, then it would be sex
So
discrimination.
I do think we have to take a step back and ask for the common understanding of these terms in this society. And so, and especially at the point of 1964. And there, sex referred to a distinction between males and females.
Are you asking that we overrule Onkale? Because I think Onkale, Justice Scalia unequivocally said, we're looking at the text, not what Congress intended. And we know that sex isn't a binary definition. Whatever people think value-wise or whatever, you know, from time immemorial, ancient Greek society, there is not necessarily a binary sex. It's because of sex that the discrimination is.
So if I could address the understanding in 1964, sex did refer to distinctions between males and females. I don't think anybody disagrees with that who's arguing today. And sexual orientation refers to distinctions between homosexuality, heterosexuality, and bisexuality. So if you
So are you
hand it-
saying we should, is this sort of an originalism versus textualism debate that we're having over?
No, this is actually a textualism debate we're having. So if you had handed the language of Title VII to a reasonable person in 1964 and asked that person, does this statute prohibit discrimination because of sexual orientation, they would have said, no, it's not on the list.
But how would you define sexual orientation without reference to the person's sex? At least if you're talking about homosexuality and heterosexuality. You have to know what the person's sex is in order to...
Right. So the argument that because you have to know a person's sex to discriminate because of sexual orientation, I do think there's two responses to that. First, you don't have to know it. Take an employer who has an application form that says, check the box, heterosexual, other. That employer would be enabled to discriminate because of sexual orientation without having any idea what the sex of the person is.
That's actually slightly different than my question. I'm saying that if the statute prohibits discrimination on the basis of sex, that sexual orientation is bound up in the idea of sex, because to define someone's sexual orientation, at least if you're talking about it in terms of homosexuality and heterosexuality and putting aside bisexuality or pansexuality, you have to know what your sex is in order to define
So
it.
again, the fact that you have to know what your sex is doesn't answer the textual because of sex question. Because of sex in this statute for a dissimilar treatment refers to motivated by sex. And you can know that somebody has a particular sex, but if you're discriminating based on sexual orientation, you're motivated by their sexual orientation and not their sex.
I just wanted to ask about Meritor versus Vinson and sexual harassment and a hostile work environment. Is your position that in order for women to have a hostile work environment claim, the harasser has to be a male?
No, absolutely not. It just has to be because of her sex in the sense that...
On the basis, okay, because of the individual sex.
Because in the sense that the person would have been treated differently had they been a male.
Mr. Gornstein, let me take you back to Price Waterhouse, though, that Mr. Unikowsky had stressed so much, the sex stereotyping. His argument heavily relies on that, and if you could just pivot to the breadth of Price Waterhouse and if you think it would go this far.
So no, because what Price Waterhouse involved is a sex-specific stereotype that a woman shouldn't be assertive, and then that stereotype was applied to deny a promotion to a woman who was assertive when that same assertiveness would not have been held against a male who was seeking the very same promotion.
So the only case that I can possibly see hypothetical that can't be covered by stereotyping is something like same-sex bathrooms. Other than that, as soon as you get into who you're dating, who you're attractive to, that plays right into, well, I expected you to conform with these norms, you're not conforming with the norms. Other than bathrooms, I don't see how all of this doesn't come within stereotyping. And let me just ask you a question while you're answering that. Do you agree with the government's position? Do you agree with the government's position on stereotyping? Because they say that stereotyping is not a violation of Title VII in and of itself. I just think it's tied to that, the answer you're going to give.
So I want to say yes, but I hope you won't follow up on it. And let me answer just the other question that the Chief Justice asked me, which is what the stereotype here is a non-gender, or it's a gender-neutral stereotype that everyone should be heterosexual. And the way that stereotype is applied, similarly situated males and females who are attracted to persons of the same sex are treated exactly the same. So that's completely different than the situation in Price Waterhouse.
Wouldn't we say in Price Waterhouse that the policy was the same? It was universalistic, not sex-specific. It is everyone should conform to traditional gender norms.
Yeah, and I think that's not the policy here, that nobody's saying everybody has to conform to traditional gender norms. They're saying they have to conform to heterosexual norms.
So if the employer says lesbian employees are okay, but gay employees are not, is there a Title VII claim?
There absolutely is. That's discrimination because of sex, because similarly situated people who are similarly situated in terms of their sexual orientation are being treated differently, and the only reason they're being treated differently in that situation is because of their sex.
Counsel, is there any relevance to the Obergefell decision and its predecessors that have fundamentally changed the way that the Constitution, the law, looks at sexual orientation? Does that have any relevance at all to this?
I don't think it does, because constitutional interpretation can't affect what the meaning of Title VI was in 1964. And if I could return to 1964, because I think there's another crucial point about it that addresses all of the plaintiff's theories here. And that is, at that time in 1964, practically every state had a prohibition against homosexual conduct, and the American Psychiatric Association had identified it as a mental disease. Now, this court presumes that Congress does not usher in vast social change through language that is indirect and vague on the subject.
Well, let me ask you another question about 1964, because of course that's pre-Loving. So do you agree with your colleague? Your colleagues submitted that everybody agrees that firing someone because of the race of their romantic partner is race discrimination. Do you agree with that?
Absolutely.
Okay, so why is that at all obvious? First of all, that's pre-Loving, so it's not necessarily obvious that everybody would have thought in 1964 saying you can't discriminate based on race means you can't fire somebody for being an interracial.
So I actually think it is obvious, and it was obvious to the court in Loving not that much longer, unanimously. So,
But there were states that prohibited it, just like you're saying states prohibited this conduct.
Far fewer, and at the same time, the language is absolutely clear on that. And let me go, and whereas it isn't on this, and so let me go to the difference of why these are different. Interracial association discrimination is a form of racial discrimination. It's not based on a different personal characteristic, whereas sex and sexual orientation discriminations are two different forms of discrimination because they're based on two different personal characteristics. And another way of looking at this is interracial association discrimination rests on a belief that one race is better than the other, is superior to the other. Sexual orientation discrimination does not rest on the belief that one sex is better than the other.
What kind of claim is that? Is that a claim about inherent? I guess I'm just not sure it feels to me that the way the court would, at least, I understand there's the language about white supremacy in Loving, but I think the way the modern court would think about Loving, that's just a racial classification. It doesn't matter why you did it. It doesn't matter what your reason was. That's a racial classification.
Right. I do think that it is. That was my the first point I made. The second point I made was slightly different, but the first point I made is that interracial association discrimination is just a form of racial discrimination. It's not based on a different personal characteristic, whereas sex and sexual orientation discrimination are two different forms of discrimination because they're based on two different personal characteristics. If I could make one further point about the legal context, and the legal context is what happens after 1964? And there's two significant developments post-64. First, Congress enacts multiple civil rights statutes that cover sex and sexual orientation separately, as separate categories. And now, under the related statutes canon, you read those related statutes together with Title VII as if they were one statute. And when you look at it that way, it's clear that when Congress wants to cover sexual orientation. It does that through a separate category.
What do you say, though, to your opponent's suggestion that, it also says race or color?
Well, race or color actually are covering two different things. You can have a colored.
Some overlap, surely you.
There's definitely overlap, and so the real point that addresses is this belt and suspenders. Is this a belt and suspenders situation? So Congress uses belt and suspenders when two terms mean the same thing or almost the same thing, like cease and desist, and it doesn't want courts to think there's something significant about dropping one out. Here, it's just not plausible to think this was belt and suspenders, because at the time, first of all, the ordinary understanding of the terms, as I've said, is that they're two different things. And then every court and the EEOC had said they're two different things. And so when Congress puts them both in, the only plausible inference is that put them both in because they thought they were two different things and they wanted them both covered.
Yeah, but counsel, based on your point about the classification of homosexuality as a mental disorder and so forth, with our air pollution statutes, as new pollutants are discovered or once materials thought benign or discovered to be actually dangerous, the authority to regulate them increases. Right here, we have is this analogous in any way? You had something that was misunderstood as a mental disorder. Many of those views were based on prejudice. As that knowledge has changed, even here on this court, doesn't the word take on its natural broad meaning? It's a very broad term, Zach.
Well, so I think it does take on its natural meaning, but it's always had its natural meaning, and that's the distinction between males and females, whereas sexual orientation had then and has now the same meaning. It's a distinction between heterosexuality, homosexuality, and bisexuality. If I could return to the point of the other legislative development I wanted to get into, which is this. Against the backdrop of an EEOC and Court of Appeals consensus that Title VII didn't cover sexual orientation, and repeated efforts to enact bills that would have overturned that consensus, Congress did the following. It amended Title VII to counter interpretations that it did disagree with, while retaining the discrimination because of sex language that had received a uniform construction.
Counsel, during that time period, though, sex stereotyping certainly was a doctrine that courts recognized and this court recognized to get at discrimination based on, somebody not being feminine enough or being too feminine, right? So sex stereotyping existed throughout that.
Oh, yes. If an employer adopts a policy of treating effeminate males less favorably than effeminate females without regard to their sexual orientation, that's discrimination because of sex. And similarly, it would be a separate act of discrimination.
Why does it have to be without regard to? Why can't that be a factor that's considered in the stereotyping analysis? I would certainly think that our precedent would allow that to be evidence that would be relevant under your reading of Onkale even, or Vincent, it would be relevant, even perhaps not under your view dispositive, but it would be relevant.
So I'm not going to say evidence isn't relevant, but the ultimate question for the jury will be, was this because the person was effeminate, or was this because the person was not heterosexual?
Wasn't conforming to stereotypes based on sex.
I would say if the reason is because the person is gay, that is discrimination because of sexual orientation. If it's because the person was perceived as effeminate, that's different. Now, the point has been made that this is a difficult factual inquiry in some cases, and I'm not going to deny that that's true, but there are other comparable, difficult, practical inquiries that have to be made under Title VII and related statutes. For example, alienage and national origin. A jury has to figure out, is it alienage or is it national origin? In 1981, you have to figure out whether it's ancestry or is it national origin. One's covered, the other isn't. And in every Title VII case, the reality is, unless the plaintiff has either direct evidence or a similarly situated comparator, the plaintiff is going to have a difficult time proving that the discrimination is because of sex, and that's in every case.
Counsel, can I make sure I understand your position on our bisexual worker? She dates a man, everything's fine. They break up, she dates a woman, she can be fired.
Based on the fact that she's bisexual, yes, and the reason is...
Started dating a woman, she can be fired. And you think that that's what a statute that was intended to eliminate discrimination in the workplace?
Well, not all discrimination in the workplace, just discrimination because of sex and the other categories that are identified there. And in your hypothetical, yes, the person knows the sex of the person she's with, and from that, she infers that she's bisexual. But the question is, the because of sex question.
Risk she was taking.
No, I would say that what she knew, the employer knew, was this statute only prohibits discrimination because of sex, and that means action motivated by the person's sex. And this action that you referred to was not motivated by the person's sex, it was motivated by the person's sexual orientation. And as long as she treats the employer, bisexual males and bisexual females, the same way, that's not discrimination because of sex, that's discrimination because of sexual orientation.
Counsel, you
Counsel,
keep
we're hearing-
drawing this distinction between because of sex and sexual orientation. How can you be so sure that they're such distinct categories? Why isn't one's sexual orientation bound up in and go hand in hand with as an expression of one's sex?
So, Justice Barrett, I think first I start with the fact that these are two different terms with two different meanings. Males and females, and bisexuality, homosexuality, and
So the word sex
so-
appears in both. And
yes, but it's a
that's
different,
sexual-
and you know, there was the original argument, by the way, just to refer to the EEOC's initial position and what it struggled with. What it struggled with was whether the term sex referred to sex as we normally understand it to mean males and females in this context, or whether it was talking about the physical act as well. And if it was talking about the physical act of sex as well, maybe it would include sexual orientation discrimination. But then the EEOC came to the conclusion, rightly I would think, that the use of the word sex in Title VII, along with all the other characteristics that it's standing with side by side, is referring to the difference between males and females
what do you
and
say to Judge-
not the sexual act.
Judge Katzmann's opinion, which I think is very much along the lines of Justice Barrett's, that sex orientation is a function of sex.
Yeah, so by a function of sex, what the judge meant in the Second Circuit was that in order to discriminate because of sexual orientation, you have to know the person's sex first. I've already made my point about why I don't think that's so, but let me assume it's so. The statute doesn't prohibit knowledge about sex, acting based on knowledge about sex. It prohibits discrimination because of sex, and that means discrimination that is motivated by the person's sex. And as the court said in the Abercrombie decision, there's a difference between knowing about somebody's characteristic and being motivated by it.
Go back, because I think this actually turns out to be surprisingly important for me. So would you agree that if our society did not conceive of sexual orientation as a separate identity, this would be discrimination based on sex?
So it's hard for me to think about that, but I do think the basic thrust of my position is that these are two and have always been understood at, and certainly were understood in 1964 as two different personal characteristics.
The difficult thing, I think, is you said in response to Justice Barrett, this is sort of a merging of Justice Barrett's question, Justice Heytens' question, and my initial question, is that you said that there are two different concepts, but the only concept that we care about here is the one that the statute mentions, which is sex. So I think we are in Heytens land, and you're the one who keeps trying to impose this external category, sexual orientation, onto the statute. All we care about is whether this is discrimination on the basis of the individual's sex. So I think you can actually forget that there is this thing out there, sexual orientation.
So if can I
You can answer the question. Briefly.
So I do think that you still come back to whether it is because of sex, and in order to decide that question, you have to ask whether it's motivated by the person's sex. And the fact that you're aware of the person's sex doesn't show that you're motivated by it, and what proves that you're not motivated by it is that males and females who are both attracted to persons of the same sex are treated the same way. Thank you, Your Honor.
Thank you, Mr. Gornstein. Mr. Unikowsky, you have 3 minutes.
Thank you, Your Honor. I'd like to make 2 points in my rebuttal time. One having to do with this concept that sex and sexual orientation are different things, and one about the equal opportunity harasser. So on the first point, it's true in a trivial sense that sex and sexual discrimination mean different things. They're not synonyms in any relevant sense. And we're not saying that they are. All we're saying is that when you discriminate on sexual orientation, you're also discriminating on the basis of sex. So just to give an example, suppose an employer had a rule saying all mothers are fired. So that would clearly violate Title VII. But that doesn't mean that motherhood equals sex. Those are fundamentally different concepts. It's just every time you're firing a mother, you're firing a woman with children, and therefore you're discriminating against women and in favor of men. And it's the same thing here. Every time you fire someone on the basis of sexual orientation, the fact that they're of a particular gender attracted to someone of the same gender is factored into the decision-making. So it's just one type of discrimination on the basis of sexual orientation that inexorably leads to a different type of discrimination, which is discrimination on the basis of sex. And the second point is about this equal opportunity harasser. And I wasn't sure exactly the response of my colleague in this case. At one point he said that maybe if it was the same supervisor, there'd be one rule. If it was different supervisors, a different rule, which is hard to locate in the statute. But it seems to me that there just is no good answer to that question. So if the answer is no, if equal opportunity harassment does not violate Title VII, then that's a pretty remarkable result. First of all, you're effectively overruling Price Waterhouse because you're in a world where as long as the employer that sex stereotypes of women and also men, they escape all liability, which is completely inconsistent with the reasoning where that would be more sex discrimination rather than less. You're in a world in which racial discrimination or racial harassment of one race is excused by racial harassment of a different race, which I don't think Congress would have intended. To me, that result is just inconceivable based on the reasoning of Price Waterhouse. But if the answer is yes, if the equal opportunity harasser does violate the rights of both the woman and the man, then it seems to me virtually all of the arguments of the employer go away. Because first of all, the argument of the employer is we're treating men as a class equally to women as a class. Same thing in that case, right? You're treating men as a class equally to women as a class. You're harassing both. The argument by the employer that inherently anything that the comparator group should be men who are attracted to men versus women who are attracted to women. Same thing here. You'd say the comparator group is men who are effeminate versus women who are overly masculine. There's both being fired, and so there's no discrimination. And so it seems to me that those arguments, if you don't agree with them in the context of the equal opportunity harasser, you also shouldn't agree with them in the context of sexual orientation discrimination. And in fact, we think that, as I said in my earlier remarks, this is just a special case of Price Waterhouse. It's just one way of being gender nonconforming is to be attracted to someone of the same sex. Look, I seriously doubt that Price Waterhouse would have come out the same way if the employer said, well, our defense to liability is that Ann Hopkins was acting too much like a lesbian. That seems very unlikely it would convince the court, and yet the implication of the employer's position is that that would have been a complete defense to liability. And without further ado, I rest my
Thank you, Mr. Unikowsky. The case is submitted. Okay, we're going to go deliberate and do what the court usually does over 4 weeks in 5 minutes. So actually 10 or 15. So it's a break time and we'll be back to give our ruling. Thank you. First, thanks so much to our advocates who are excellent. We have a ruling to announce, but first, I just want to stress again the educational nature of this and how none of us have voted necessarily our points of view or how we think the justice will vote. We have actually a bad track record when it comes to the justices. But the main thing we want to stress is how good it was, and to prove it, we have gifts. First, Adam and Irv, we just want to give these to you before we tell you how we ruled. Bravo, bravo. And this is on behalf of Wilson Mary Law School. Thank you. And we have the court has split 5-4 in favor of the respondent. And Justice Bravin will have the opinion for the majority, and then Justice Heytens will announce the dissent.
We have no doubt that the Congress, the past and the president who signed the Civil Rights Act did not have this type of category in mind at the time. President Johnson himself famously dismissed his own aide, Walter Jenkins, because of his sexual orientation. And if the president wanted to reserve that right to himself, we cannot think that he would seek to deny that same right to employers in general. Looking more broadly, we have to think about the backdrop of the Civil Rights Act and the restraints it places on employers. The baseline in our free enterprise system is the freedom of the economic actor to do as he or she sees fit. There are times when that should be restricted or regulated for the public good, but we believe the default is for the freedom of the individual actor rather than the restriction, no matter how benign or how beneficial we individually may think that restraint may be. So, absent an explicit announcement or pronouncement from the Congress that sexual orientation is a protected class, we decline to extend the meaning of Title VII to that class at this time. And we think that this distinction is important in light of our decision earlier today in the Harris Funeral Home, where we found that, by the same vote, that discrimination against the transgender employer was clearly an instance of sexual stereotyping that we have long held is prohibited under Title VII. So and we invite the Congress, if they disagree with either of those decisions, to make its views known through appropriate legislation.
Thank you. And this dissent feels so strongly, it will dissent from the bench.
We think this case is a straightforward application of the text of the statute and our precedents, both of which would independently support the conclusion other than that the majority reached. First, when it comes to the text, we have heard no persuasive argument to the idea that if you fire someone because of the sex of their significant other, you are doing so by reference to the sex of the individual. And so we think that although the employer argues that sexual orientation is this separate category, we think that takes a category that, regardless of whether it exists in some abstract sense, that is not in the statute, and inserts this into the statute. So we think this is textually the same thing as firing the female employee who smokes and not firing the male employee who smokes as a matter of text. In response to the argument that that's not what the people who wrote the statute would have anticipated, this court has repeatedly said we don't look to the subjective intentions, we look at the words they used, and we think the words they used resolve this case. Separately and independently, we think this is resolved by Price Waterhouse and our sex stereotyping cases, specifically the equal opportunity to harasser hypothetical and a variety of the others that we think, regardless of whether we think the text of the statute resolves this, we independently conclude this is an example of sex stereotyping, that discrimination based on sexual orientation is necessarily sex stereotyping, and as a result, the four of us have noted our dissent.
Thank you. We thought, given the quality of the advocacy and just the general nature of how tightly this case might truly end up being decided, that some people might have questions of Irv or Adam, who prepared the case, or any of the justices up here. How much time do we have, Neil?
10 minutes.
Okay, if anybody has any questions. Well, then we'll have a break. Thank you again. And as I just want to, since Irv, you hadn't argued before this in Williamsburg before, have you, with this?
No, and I never will again.
Well, I think the only reason I wanted to just add this, pretend we're now out of our robes, this was the first time Adam had even come. So I just want to say that it has nothing to do with, in fact, we had a lot of switched votes in conference. Let's just put it that way. So thank you so much for the time and effort that goes into this. A couple of the pretend justices up here have argued it, and so much of the argued at other sessions, and so much of our conversation had to do with how hard that is to put oneself on the line. So thank you again, and thank you all for being here. And the next panel will start in about 7 minutes. Thank you.